but you should be able to hear us, and you should be on mute. If you are having trouble with, uh, if we're having trouble, I may have to mute everybody in the room if somebody starts making a bunch of noise in the background, but everybody should be muted. And if you go to the bottom left-hand corner of your screen, there is an audio setting down there that says either join audio or stop audio. And there's also a stop start video that's down in the bottom left-hand corner. So I would appreciate it if everybody in the bottom left-hand corner goes to the stop video and turns their video off unless they're presenting. Um, and that's just, we don't need to see everybody's face, and it's not displaying for everybody, but it's just something that'll lag the system down a little bit more than usual. But everybody should be on mute except for the presenters. If you are unable to, well, I guess if you're unable to hear me, then you're not hearing me right now. So I should think about that. We've decided that today to use the chat feature in this conference room. So if you go to the bottom middle of the screen, there's a little icon that says chat with a little bubble. When you click on that, it will say Zoom group chat, and that is where you can ask questions throughout. Angie Volk here is monitoring those questions. And if you have any questions regarding anything to do with watching or anything in the meeting, you can contact somebody here at the State Bar, and we'll get back with you. But yeah, the camera at the State Bar is, well, I think it's the lighting on our camera. I think it's there's a dark window. So sorry about that, but there's a bright window behind us and the room's kind of dark. So but I'll turn it over to Angie now to.
All right, yes, again, good morning. Welcome to our intellectual property seminar. This seminar has been approved for 3 CLE credits. You will be given live attendance credits if you are participating via video conference. You can be approved for 3 online credits if you're participating by phone. Hopefully everybody knows by now that we did get an order from the West Virginia Supreme Court a couple of weeks ago lifting the limitation on online credits for this reporting period. So you can get unlimited online credits towards your 24 CLE credit requirements. You will get an email to confirm your credits for this seminar, so you do not need to self-report them. Just wait until you get that email from Mike to confirm the credits. Again, don't self-report them, or do that and then also confirm them. You're going to cause a duplication on your CLE transcript. You have to accept the email that you from the State Bar in order to confirm the credits. The hours will not be added to your transcript unless you confirm them. So if you don't, for some reason, aren't able to participate in all 3 hours of our seminar this morning, you can edit those credits to the amount that's appropriate for what you were able to complete. If you don't receive that email about confirming the CLE credits, make sure that you check your spam because it may have ended up there. We are going to be able to have this videotaped. It will be available later if there is a part of it that you miss, or if somebody missed the entire seminar and wants to get the CLE credits, it will be available later. So I think that takes care of all the housekeeping announcements. So I'm going to turn it over to Michael, who's going to introduce our first speaker, and we'll go ahead and get started. And again, we'll try to do it in 3 50-minute segments. So there will be a couple of short breaks in between the first and second and third presentations. So Michael.
Michael, we can't hear you. So I don't know if you're muted.
Yes, indeed, I was. Sorry about that. Good morning, everybody. I'm Michael Ellen Suzuki Bennett. I thank you for being up with us and joining us on Zoom this morning. I hope everybody's healthy and safe. So this morning at the 9 o'clock hour, we are lucky enough to have Marion Armour-Gemin from WVU. She has been the patent and trademark librarian at WVU since 2003. She will be presenting at the 9 o'clock hour, copyright for consumers and their attorneys. And at the 10 o'clock hour, we are going to have a panel with intellectual property discussion panel. If you want to submit questions ahead of time for the panel, that would be excellent. Or as we go along in the panel at the 10 to 11 o'clock hour, that would be great. And that's going to be myself, Michael Ellen Bennett, Robert Bandy from K Casto, and Kevin Levine, and he practices in West Virginia and Tennessee. And at the 11 o'clock hour, I'm going to be presenting, which is a business and office management credit, getting registered as a patent attorney with the United States Patent and Trademark Office. So with that being said, let's pitch it over to Marion.
So good morning to all of you. I just wanted to briefly say, let's see if I can. I have been the patent and trademark librarian since 2003, and I'm not an attorney. I am part of a program which is called the Patent and Trademark Resource Center. The United States Patent and Resource Center has designated over 80 patent and trademark resource centers in the U.S. and Puerto Rico. And the Evansdale Library at WVU is the only patent and trademark resource center in the state of West Virginia. So as a Patent and Trademark Resource Center, I provide intellectual property assistance to inventors, but no legal advice. So I try to direct them to things that they can read and to interpret on their own. And if they're not sure of the interpretation, I try to direct them to attorneys. So I primarily present on patents and trademarks, but today Michael Ellen has asked me to talk about copyright. And of course, as since I am in an academic institution, we look at copyright often. So the outline today is I'm going to be talking about what I would talk to consumers, and so you would have an idea of what kind of guidance librarians give consumers, so that when you talk to them, you have an idea of what we talk about, and then maybe just kind of give you a brief review of what copyright is. Also talking about copyright coverage. We'll talk about reusing content, the Copyright Office webpage, and then we'll talk about fair use and reuse review. So actually there's 4 types of intellectual property, and I'm seeing that my internet connection is unstable, so I'm hoping it will stay stable for us. A trade secret is something which has economic value because it is not generally known or easily discoverable by observation, or for which efforts have been made to maintain secrecy. So some common trade secrets would be Kentucky Fried Chicken secret recipe, or WD-40. Those are some. You can probably think of some others. And then there's trademark, which is a word, name, symbol, or device that's used in trade with goods to indicate the source of goods and distinguish them from the goods of others. So we are all now very familiar with different package delivery services, such as UPS and FedEx. And both of those, we know that they deliver packages, but they both have different trade names, trademarks. And we know that UPS Brown, they deliver, and they're a little bit cheaper than FedEx, if I'm going to pick one, but FedEx, has another anticipation. So we know that they're operating in the same area, but but they have different marks, so the consumer knows which one, which company they're dealing with. And then patents are, it's a property right that's granted to an inventor to exclude others from making, using, offering for sale, or selling the invention. Finally, copyright is a form of protection provided to authors of original works of authorship, including literary and certain other intellectual works, both published and unpublished. And that's what we're going to talk about in this session. So copyright is a form of protection provided to authors of certain works of authorship, including literary and certain other intellectual excuse me, there was an interruption. So it gives the exclusive right to reproduce copyright work, prepare derivative works, and distribute copies, among other things. Currently, a work does not have to be registered to be protected, but you cannot bring suit unless the work is registered. So registration is very important. Copyright protects the form of expression rather than the subject matter of the writing. For example, a description of a machine could be copyrighted, but this would only prevent others from copying the description, and it wouldn't prevent others from writing a description of their own or from making or using that machine, because those are covered by other things. Okay. There are 3 basic requirements for copyright protection. It needs to be original. It is independently created and not copied from something else. It doesn't have to be novel, unique, or imaginative, or inventive. It has to be creative. At least it has a small amount of creativity, not just a list of facts like a phone book, because that would not be copyrightable. And then it has to be fixed. It has to be fixed in a tangible medium of expression. So copyright covers lots of different things. Literary works, like books, magazines, and web pages, musical works, dramatic works, pantomimes and choreographic works, pictorial, graphic, and sculptural works, motion pictures and audiovisual works, sound recordings, and architectural works. Copyright does not cover ideas, procedures, processes, systems, methods, concepts, or discoveries. It doesn't cover facts, names, titles, short phrases, typefaces, blank forms, or familiar symbols and designs. Copyright protects the expressive content and not the underlying thoughts or ideas. It has to have a spark of creativity. It must be a fixed work that you can see or hear. It does not need to be permanent, but it cannot be short or transitory. It cannot be an improvised performance that has not been written down or recorded. So currently, the law changed a few years ago, and currently a work doesn't have to be registered to be protected, but you cannot bring suit unless the work is registered. Copyright is an exclusive right to reproduce the copyrighted work, prepare derivative works, and to publicly display and distribute copies, among other things. So the term of copyright for works originally created on or after January 1978 is life plus an additional 70 years after the author's death. And for works made for hire, it's 95 years from publication or 120 years from creation, whichever is shorter. Intellectual property, copyright is probably the cheapest. The fees are very low, and you have to have an application form, a non-refundable filing fee, and a non-returnable deposit. So it's $35 for a single application electronic registration. And it's $55 for standard application using the electronic filing. And then if you need to use a specialized form, it's $85 for Form TX, VA, PA, Form SE, or Form SR. And those are only through the mail. So you can see it's a lot cheaper than the filing fees for even a trademark, and of course for patent is a lot higher. So just reviewing these 3 basic requirements to qualify for copyright protection: it has to be original, independently created. It doesn't have to be novel or unique. It has to be creative, and it has to have at least a small amount of creativity, and it has to be fixed in a tangible medium. So what I thought, if we were all in person, we'd have we'd have a worksheet, but we're not in person. So I thought, well, I'll just do it on slides, and just to have you think about some questions and in your mind, and think about whether this is copyrightable. And I don't really have a really good way for you to participate in this, but think about this for a minute. So would an email that you sent to your grandparents be copyrightable? So think about that a minute or so.
Hey, Marion,
Yes.
we had a question on your previous screen about the different forms. Somebody asked what the abbreviations TX, VA, and PA mean.
Those are different forms that the Copyright Office has. And that's what their abbreviations are. Okay, going back to the questions. Would an email that you sent to your grandparents be copyrightable? Well, it would depend on how long it was. If it was very original, if it was just a really standard, hi, Grandma and Grandpa, I hope you're feeling good, love you, bye. That wouldn't be copyrightable. But if you had a longer explanation in there, that would be copyrightable. What about that amazing sunset photo you uploaded to Instagram? What do you think that would be copyrightable? It would be, but why is it on Instagram then? How can other people use it and forward it and post it again? What is going on there? Well, you are signing a license agreement when you're using Instagram, and that allows them to repost your photo. So you have given permission to have it shared. So you still retain the copyright, but you're allowing Instagram to forward it on. How about this? The idea you verbalized during the Chamber of Commerce brainstorming session. Think about that a minute. And I wish we could have a discussion about this, but I guess we really can't. Okay, so notice it was verbalized, so it wasn't in written form. It wasn't written down. So when it's not written down, and maybe it wasn't, so it wasn't in a fixed medium, so then it wouldn't be copyrightable. But if someone took minutes, then perhaps that it was written down in a fixed medium, then it could possibly be copyrighted then if it was taken down in minutes. So you see how it's kind of like vague sometimes. This is why, as a librarian, I'm going to be sending vague questions to you as an attorney to figure out whether it can be or not. How about that tweet you posted explaining about your position on the rising cost of toilet paper? So I had to throw this one in for today, since this is what everybody's talking about. So once again, this is a tweet, and on Twitter, you have also allowed people to retweet your explanation. So, and I know that tweets are quite short. They're only 256 characters. So if it was very original, it might be covered by copyright. If it wasn't very, very unique saying, then probably not. So it really depends. So what I thought then I would show you, that Instagram does have terms of use, and you might make sure that you look at those terms of use. And also Twitter also has there's some information about Twitter and copyright from the copyrightalliance.org. That's Copyright Alliance is somewhere that librarians rely on. And then if you had questions about works made for hire, the Copyright Office has a Circular 9. Okay. So one question we have often is, how can I reuse some content? Because, you know, I don't want to have to make up all this stuff again. And there's some really good stuff, and can I just reuse it? So there's different options for reusing content. One is to get permission from the copyright owner. This is the safest way. You can also obtain a license. There's also, you could also employ fair use, and we'll talk later about what fair use is. Another thing that people could consider is to use public domain content, and so that they don't have to worry about copyright because it's already in the public domain. And then you could also use publicly licensed content. Licensing, this is when the copyright owner gives permission for a specific use or for a fee. And there's also something called the Creative Commons. And this gives open permission to use works without a fee. And there are different levels of Creative Commons licenses. And I'll talk about those later. And the creativecommons.org is their website. And I'd ask you all if you'd heard of Creative Commons before, but it's hard to do that today. So I often work with the creative arts librarian, and she works with the musicians at the university. And so this is some of the things she's very familiar with. So I kind of borrowed this slide from her. There are different licenses that are compulsory. In other words, that the copyright owner may not have to be consulted in order for you to get a license. So there's something called a mechanical license, which gives a person the rights to record and distribute a song, even if you don't hold a copyright to it and it isn't in the public domain. And there's a company called the Harry Fox Agency, and they help with mechanical licenses. Because if you think about it, when a musician records a song, it can be the musician, whatever they're performing is covered by copyright, but then also the people who are performing in the background, they also are contributing to the music. And then the musician is using music that might be covered by a copyright too. And then the lyrics also could be covered by another copyright that someone else owned. And then, so it gets very complicated in music. So having this option to use a mechanical license can be very helpful. Then there's a synchronization license to include music you don't hold the copyright to, and it isn't in the public domain, in an audio video work. So that would be something someone would have to obtain. And then there's also something called a public performance license. And these are the different abbreviations, and I don't really know what they all stand for, but I know sometimes in like churches, they have music lyrics on the screen above, and they're using the lyrics, and they get these licenses so they can share the lyrics, and then they pay a fee at the end of the year for all the different lyrics that they've used. There are places that centralize permission. One that librarians often use is the Copyright Clearance Center when we're using, when we're sharing journal articles more than what we think is fair use. Then there's also an art resource. There's Bridgman Images, and then there's something called Watch, which is the writers, artists, and their copyright holders that also license and give permission. So let me talk a little bit about Creative Commons. People a lot of times have needs to use images, and so they formed this thing called Creative Commons. It's a nonprofit organization, and one of their goals is to provide Creative Commons licenses and public domain tools so that people can use them free and simple. And it's a standardized way to grant copyright permissions. And to ensure proper attribution and to allow others to copy, distribute, and make use of those works. And so if you have more interest in this, it is available under the Creative Commons under their About section. And this is what the Creative Commons website looks like. Let's see, I hope I'm not going to mess something up. Okay, I don't know if my mouse will show or not. Whoops. Okay. I can't really show it very well right now, but in the very center of that, you see the words discover the new CC search. And under that, there's an orange arrow and start searching. You can start searching for a cat or a dog or a mountain, and it will give you examples of things that are available under the Creative Commons license. So the Creative Commons licenses, when you go to one of those, you'll see these little icons. So what do these icons mean? And they're, the most open Creative Commons actually would be CC 0. That would be like you can just use this wherever you want to. But often you see CC BY and then with a little person there. And the CC BY means that you can use this as long as you give attribution to the person who created it originally. And then the next one, you see CC BY, and then there's this round arrow, and it's share alike. And share alike means if this is a Creative Commons image, and if you change it, then you have to make yours in Creative Commons as well. So you have to use it, share it alike the same way with the same type of license. And the next one, there's this CC BY and then ND with the equals, and that means no derivative works. So if you had an image that you were using and you wanted to crop it or change the tone, you wouldn't be able to do that. And then NC means that you cannot use it for, you can't make money off of it. It's not, you have to give it for free. It's not for commercial use. And then finally, there's, you can have very strict when it has, you know, you can combine them. You can see how they've combined them. You can combine them in any different way that you'd like. Okay. So I'm going to move on now to the Copyright Office. Did anybody have any questions about the Creative Commons?
There was a question posted asking if somebody posted a YouTube video of themselves playing an instrument. Is that copyrightable?
Well, copyright is implied. So if you post something to YouTube, you own that copyright. Now, if you wanted to sue someone for reposting your video, then you would have to register it with the Copyright Office.
Going back to your example of somebody making an expression at I believe it was a Chamber of Commerce meeting, somebody asked if the meeting had been recorded, would that comment be copyrightable?
Well, it's certainly, the video would certainly be copyrightable and possibly the comment as well. I know I'm vague, but I'm not an attorney, so that's up to you guys. Any other questions?
If I may just say, I mean, this is Robert Bandy.
Sure.
We're going to have the panel discussion in the 10 o'clock hour, and we can address some of these questions, the attorneys, that is. We can address some of these questions at that time as well.
That's great. Thank you very much. Shall I continue then? Okay, so I'd like to talk a little bit about the Copyright Office. It's at copyright.gov. It's a federal agency. U.S. Copyright Office is a separate federal department within the Library of Congress, and it's run by someone called the Register of Copyrights. Works that are deposited are sent to the Library of Congress for its collections. And the mission of the Copyright Office is to promote creativity and free expression by administering the nation's copyright laws and by providing impartial expert advice and copyright and policy for the benefit of all. So I wanted to point out that there are primary legal resources on the Copyright Office's page. At the very top of the page, there's a place to register, there's a place for recording, and then a place for research. So you register your original work, but recording would be for assignments. And then you might need to do research into who owns a copyright. So those are at the very top of the page. There are also links to the copyright law of the US, which is Title 17. There are links to the Code of Federal Regulations, which is copyright is covered under Title 37, Chapter 2. And there is also a link to the Compendium of US Copyright Office Practices. There is also a Fair Use Index and an archive of briefs and legal opinions. So these are the primary legal resources that are available on the copyright page. Also helpful items that are available on the Copyright Office's page are a schedule of fees, a learning engine video series, and these can be helpful to look at and to understand the copyright law. There are circulars which also explain in written language what different aspects of copyright are, and then there are forms, and then you can also search copyright records. So this is what the copyright webpage looks like. And notice there are 3 main boxes: the register, record, and research. And at the very top, though, there are links to law and guidance and policy issues. And at the right-hand side, there are the links to like the copyright law of the US and the Code of Federal Regulations. And then further down on the left-hand side, we see there's resources like searching copyright records, the schedule of fees, and then under education, the Fair Use Index, and the Learning Engine video series. So under law and guidance, and now at the very top of this slide, what I did was I did a small screenshot so you could see how there's a drop down under law and guidance, and you can see where the copyright law is, the compendium or the rule book that the people use in the Copyright Office, are kind of similar to the MPEP or the TMEP in a way, and then the publications, the forms, and the circulars. It makes it very easy to find those. So what are forms? Of course, there's lots of forms, and they really would like you to file electronically. So strongly recommend doing that. And then there are the information circulars and basic facts. The circulars are helpful. There's something about compulsory licenses if you want to look at that. Under Circular 14, you can look at the copyright registration for derivative works. Under resources, you can search for copyright records, the schedule of fees, the archive of briefs and legal opinions. It talks about mandatory deposit, and of course, this is very important. All works are subject to mandatory deposit provision. You have to at least provide 2 copies of the best edition must be sent to the Copyright Office within 3 months of publication. And this mandatory deposit also applies to foreign works. So searching copyrighted works. Now this is tricky because not all copyright records are available for searching on the website. Prior to 1978, the records are only at the Copyright Office. Now they've been trying to scan the cards in for a long time, but there's lots of cards. It's a huge room with drawers with these copyright records. So you can actually go there and visit to search for records before 1978. You can also request for a search to be done so either way. But after 1978, you can search the public catalog, and you can search the catalog of copyright entries. So there's different things that you can search for. Oops. And I'm just trying to move this a little bit. So you can search for the title, the name of the person who registered it, the keyword. If you know the registration number, you can look at that. It can be helpful. And then there's education. So I mentioned this briefly before. There is a fair use index. So what is a fair use index? The fair use index is actually a list of court cases deciding fair use. And they talk about which way it was decided and which factor of fair use it was used to decide that, and it's searchable and you can limit it. So sometimes when you're working with a client, you could maybe use this to determine whether you think they have a fair use. And okay. So I just talked about fair use. Now, I'd like to talk about it more. And of course, in academia, we use fair use a lot, but other people talk about fair use as well. So I think this is an important part of copyright law. A fair use is a reasonable and limited use of a copyrighted work without the author's permission, such as quoting from a book in a book parody or using parts of it in a parody or in a book review. So there's certain, fair use has been decided on a case-by-case basis. So every time it has to be reviewed. There are basic concepts, but no formula. You can't just declare, I think it's fair use, and it's fair use. I tell people that people are trying to decide, can I do it or not? And I'm like, I don't know. You know, you have to decide or talk to your attorney. But you can always ask permission when you're in doubt whether it is fair use or not. So, and then looking at that fair use index, it has a list of court decisions and you can sort by topic. It can be helpful in deciding whether it's fair use. Of course, you know, it's whether, a lot of times when I'm teaching this in a class, then we have copyright cards, and then we have people look at what kind of risk they might have. And so people have to decide for themselves what kind of risk they're willing to have when they do things. And so we let people make their own decision about, you know, what kind of risk things would be. And I'm sure as an attorney, you're going to be guiding people with the risk. There are four factors of fair use: the purpose and nature of the use. There, my dog came to visit me, just like I promised. Okay, so the four factors of fair use: the purpose and nature of the use, nature of the copyrighted work, amount and substantiality of the portion used, and the effect the use upon the potential market or the value of the copyrighted work. So actually this first one is the primary one, but all of these 4 factors are looked at. So looking at the purpose and nature, the purpose and character of the use, areas that favor fair use would be teaching. So that's why academia, we look at this a lot, because if you're teaching it, using multiple copies for classroom use, that's allowed under fair use. Also, if it's for research, for scholarship, it's nonprofit, for educational institution, also for criticism, for commentary and news reporting. If it's transformative, it changes the works and it's in a new utility. It's restricted use to only students in the appropriate group. We have a learning system at WVU called Blackboard, and only students who are registered for that class can go in and look at it. This is a restricted use. And then also favoring fair use is parity. Opposing fair use is if it's commercial activity, if someone else is profiting from the use, if it's used in entertainment, if that faith barrier, if you deny credit to the original author, and if it's non-transformative use or a verbatim or an exact copy. And a lot of these I've gotten from Columbia University has a copyright page. It's called copyright.columbia.edu, and they have a lot of useful things on their webpage. And that's where I've gotten a lot of these from. So then favoring fair use would be published work, factual or non-fiction based. If it was important to favor educational objectives, or if it was non-consumable. Opposing fair use would be if it was an unpublished work, highly creative, like plays and films. If it was fiction, if it was a workbook, that would be consumable, and if it was a work made for educational market, like a casebook. The third factor is the amount of the portion used. So was it a small portion? The portion was not central or significant to the entire work, or the amount was not appropriate. It was appropriate for a favored educational purpose. And opposing it would be a large portion or a portion used is central to the heart of the work. So if you had the main, you quote the main phrase of the work and it reveals everything, that would be opposed to fair use. And then if the effect on the potential market. So favoring fair use is if you lawfully purchased and acquired the work, that you only made a few copies, that there was no significant effect on the market, and also there was no way to license it. To oppose it would be it's replacing the sale of the other copyrighted work. Is significantly impairs the market. There is a way to license it, and the person just ignored that license. They made numerous copies. They made it on the web in a public forum, or they used it repeatedly. So then I thought what we could do is, this was another kind of thing that I like to do in a class, and so I thought maybe you could think about these as well. And don't really have a way to participate in it, so I'll just let you think about it when I show you a question, and you can think about whether you think it would be fair use or not. So thinking about this, whether it's true or false. Kathy downloaded a few photos from a local organic farm's Flickr.com's Creative Commons pool. She followed the rules of the photographer's specific Creative Commons licenses and use them in her digital video about sustainable agriculture. Is that okay? That's okay. True or false? Well, she followed the Creative Commons license, so it's okay, because that's what the Creative Commons license is about. Okay, let's look at another one. True or false? Since Richard forgot to register his screenplay before he sent it out to the agents for review, he's no longer eligible to copyright it. Well, this is false because copyright is now implied. You don't have to register it. However, if he wanted to sue them for copyright infringement and he hadn't registered it, he'd have a hard time. So it's important to register it in order to bring suit. So, okay, here's another example. Sam buys an MP3 from iTunes and then decides he doesn't like it, so he resells the MP3 to his friend. This is legal, right? True or false? Now remember from our discussion about Instagram and Twitter that there were license agreements. Well, with Apple iTunes, there also is a license agreement, and it says that you cannot resell MP3 files to someone else. So looking at those long licenses, and it would not be legal. Okay, so here's another example. Biff has designed mugs with a dramatic bridge photograph, and he plans to sell them to raise money for Engineers Without Borders. And so he got this photo from Getty Images, but he is, you know, there's a watermark on there, but he's not really worried about it. He can easily Photoshop that out. Is this fair use? I mean, he's selling it. He's raising money for Engineers Without Borders with this, which is a nonprofit. But he's making money, right? So it isn't fair use because he should have licensed that image from Getty Images or asked permission. Okay, so it's not fair use. Here's something else about YouTube. So Adam recorded a video for his YouTube channel about the upcoming Senate elections, United States Senate elections, and includes an official photo taken by a government employee and 4 bills authored by the incumbent that Adam found on the U.S. Senate's website. That's copyright infringement. Yes or no? True or false? Well, actually, this is false because works produced by the U.S. government or any U.S. government agency are in the public domain, and texts of legal cases and statutes produced by the federal government are also in the federal. However, of course, a work needs to be cited, but that's something else. But so I know you all pay for the texts of legal cases, and this is something librarians have been arguing a long time about because those come from the government. But then you pay to a vendor to compile them, and then the compilation and the license agreement that you sign, you know, then you start agreeing to pay for something. But the actual text of the legal cases are in the public domain. Okay, true or false? Justin downloaded the black and white horror classic Night of the Living Dead from the Internet Archive. He decided to fix it. Audio sample in film with one of his original songs. That's copyright infringement. True or false? Well, notice I said Internet Archive, so that kind of gave you a clue. The Night of the Living Dead is a movie about zombies, and this has, it entered the public domain because they forgot to put their copyright notice on it. So this is back before they changed the law, and you had to have a copyright notice on everything in order to have copyright protection. And because they didn't have the copyright notice, it entered into the public domain. So it wouldn't be copyright infringement. And he can use it as much as he wants. Okay, is this fair use? Dean wanted to include video clips from Olympics illustrating the importance of a photo finish. She will only use about 15 seconds from each race. Can she do this? Wow. This is a complicated one, isn't it? Okay, so we're going to ask these questions. Is it transformative? How much of the original video is she using? Okay. What is the purpose of the video? All these things you'd have to do with consideration. How would you advise your client? And the final example here is how great is the risk? A student finds a table of statistical formulas in an online textbook and wants to use it, a table in a class assignment. So this is the table. Well, we all know this table, right? Okay, so let's look at the issues. Is a table protected by copyright? Well, is it original? It probably isn't original, is it? It's not really inventive. Okay, maybe someone invented it a long time ago, but it isn't original anymore, right? Is it creative? It kind of is a list of facts. So and is it an effects or tangible minimum? Yes, it is, but it's not any of the other two, okay? And then, is it the proposed use covered by fair use, or is it one of the special exemptions? So the nature and character of the use, the nature of the copyrighted work, the amount of substantiality portion used, and the effect potential market. So just looking at those. So before I go to questions, I just wanted to bring up something that recently came up, and this has to do with fair use. And I didn't make any slides on this because I found out about it after I made all the slides. And one of the things that we're dealing with right now, the libraries is that most of the universities have gone online because of the coronavirus. And so a lot of there are copyright attorneys who work at the larger universities, and they've come up with a statement on a public statement of library copyright specialists, fair use and emergency remote teaching and research. So because we have fair use and we use things in the classroom, we're allowed to do that. But there was another law with the DMCA, the Digital Millennium Copyright Act. And then when it goes online and is used like in a video or streaming, it's a lot more restrictive in fair use. And so this is a statement that's been signed by probably over 100 people, looking at the fair use and looking at looking at the heart and character and purpose of the use, and that it would benefit people, and also looking at different case law, since there's nothing about the public health crisis, but they looked at other cases like the Authors Guild versus HathiTrust, which made it clear that people had persons with disabilities would be in the strong public interest to let them use those works, and there's a lot of other. They looked at that factor. They looked at the second factor, saying it wasn't. It rarely plays a significant role. And the third factor, the amount and substantiality. So they're looking at, there's no specific rule, like is it 10% of the book or whatever. And then the fourth factor is the effect. And so they're looking at moving, they don't have much time to check for licenses. They would if they could. So they're trying to do that, and campuses can restrict it through this, like Blackboard, to students only, and it's going to be for a limited time. So they're trying to justify using some materials that they normally would use in the classroom, using it online, because they normally could. Looking at the fair use factors. I just wanted to bring this up because librarians are really thinking about this. What's interesting is that publishers are realizing this as well. And so we actually have long lists of publishers that are allowing us to temporarily use works that are copyrighted for the end of to the end of the semester. Some of them are giving us 30 days, some of them are giving us 60 days, some are a little bit longer than that, so that they're kind of enforcing in ways saying we still have the copyright, but you can go ahead and use them. And so I think this is a generous way for them to do that, and also to show us, you know, what works are really important. And our users will say, oh, we really like that when we could use it for free. Publishers are working with libraries as well. So I just wanted to conclude with that, something current today in copyright law. So that's what I have today.
Thank you, Marion. We got started with the actual presentation, of course, a few minutes late because of the announcements we had to make. So to get us back on schedule, we'll take a break for about 5 minutes and start with the panel discussion right at the 10 o'clock hour. And there were a handful of questions that came in during Marion's presentation. So we'll try to catch those in the panel discussion starting at 10.
Okay, thank you.
Okay, everybody, it's about 10 o'clock, so we'll go ahead and get started with the panel session. I'll turn it over to Michael to get that started. I don't know what you had pre-prepared. You can maybe deal with that first, and then we can go back and catch some of these questions that came in during the first session.
Let me, this is Mike at the State Bar here. Let me go ahead and say, if possible, on your video conference window, if you can go down to the bottom left-hand corner, if you are not a presenter, and go to stop video to turn your video off, that would be helpful so that we don't have all these windows up here. and we just have the presenters. So I'll turn it over to Michael now.
Thank you. I really didn't have anything to say here on the panel to kick things off, but I think that the questions that were generated by Marion's presentation are a perfect starting point. If we want to just kind of go ahead and dive into some of those, some of them look like they might.
Michael, this is Robert Bent. Is Kevin Levine on the?
I am.
Hey, Kevin, how you doing?
Doing well, Robert. How are you?
I'm doing fine. So just wanted to make sure you were on here as well so we can have everybody involved in the panel. Sorry, Michael, I just wanted to make sure he was on.
No, it's perfectly fine. If you want to moderate, Mr. Bandy, that's fine too.
I'd just like to say that I think we have a good panel here in the sense that Michael is involved in patent work. Kevin Levine has a thriving, if I can say that.
I'll take that.
Is in intellectual property practice, both here in West Virginia and in Tennessee. So I think he's would be great to answer some questions regarding how copyright in the music industry. And of course, we still have Marion involved, that she can answer some questions about the ins and outs of getting that copyright registered or whatever. I saw some questions on that some of the individuals sent. And if I may, just on copyright issues, I'd like to stress the idea of registering. The big benefit that you receive from registering your copyright would be the statutory damages. So if you have an infringement and you want to sue on that infringement, you definitely want to be able to get or try to get those statutory damages. And of course, the big thing is the attorney fees. If you're registered within the time period and you sue for infringement, the big part of that is that you get your attorney fees, or may be able to get your attorney fees. Of course, the sooner you register, the better off you are. If you register within 3 months of the first publication, then you're set, no matter if the infringement occurs after or before that registration. However, if it's you want to be able to register, you have to register prior to the infringement if you want to have any chance of getting your statutory damages or attorney fees. So that was one of the questions I believe that we had from somebody participating. So I had that, taken some notes on that, wanted to say that up front. And I believe there may have been a question here regarding copyright involving music, if I'm not mistaken.
I think that there was, but one more thing about the damages with registering a copyright. If you, I actually have a client now that she's an artist, and we're kind of going to use her case as a textbook case. She has done everything right. She registered her copyright. She kept all of her contracts to license them out for limited prints to run with these different companies. But with regarding to the damages, you absolutely, Mr. Bandy's absolutely right. Register to protect yourself and avail yourself of the maximum damages there for your copyright violation, because there are $150,000 per violation that you can seek under the federal law. However, if you don't have it registered, as Marion has stated multiple times, it's still the copyright is implied, but the damages that you are entitled to are simply the damages, the lost revenues from, say, they made $100 off of one sale of your work. You're entitled to that $100 as opposed to the $150,000 that you would be entitled to under the federal law. So always advise registration. It is a small amount of money for a potentially huge return in a situation like my client's now.
Yeah, and also registering, of course, is prima facie evidence of the validity of your copyright. So
Exactly.
if you are registered and have to go to, you have to file suit, then I mean that takes care of a big part of your case in the sense that you don't have to have the proof of validity of your copyright. So.
I'll tack on there. I mean, a lot of times it's just cost prohibitive for somebody to, pursue an infringement claim. I mean, I'm trying to be diplomatic here, but certainly from a commercial viability standpoint, certain copyrights have more value than others. Take creativity and artistic value out of the equation, and it's a difficult conversation to have with a client as to how much it's going to be to pursue an infringement claim when the reality is it's not a strong income producing copyright and probably will never be, just being blunt.
Let's see a question here regarding, and I'm sorry if I'm taking the last question first, but that's just the one I see. But what happens to a copyright when the copyright holder passes away? This person says they think it's considered personal property and passes as part of the estate unless otherwise addressed in a will and continues to endure. But what does it then, and who does it then belong to? Anybody have any thoughts on that as to how it passes on?
It is treated like personal property. It's intellectual property. It's like a car, unless it's specifically addressed in a will. The laws of descent for your state will apply to the right to it, and that's again the right to receive royalties. And as Mr. Bandy had said, if it's registered, different ball game than if it's not registered. So, if you're wanting to pursue violations of the copyright, if it's registered, the right to pursue that violation passes just in the absence of language in a will or codicil. It would pass just like intestate succession in your state.
Right. And Marion, here's a question. Looks like for you. If you have, do you have to have separate registrations for each copyright work, or can you have a bulk registration if you're posting quite a bit of stuff?
So I was recently talking to a poet, and we were talking about bulk registration. So you can actually, like if you have a collection, you can register those all together as one registration. It's not the simple registration fee. It's a higher registration fee. And I guess I didn't update my fees. Someone pointed that out on the chat too. The fees went up on March 20th, and I knew they were going to go up, but I don't know. I just didn't think to look. And they've gone up a bit. But it's called a, it's a bulk registration fee. So the cost is just a little bit more, but it's not significantly more. It's like $15 or $20 more to do a bulk. That answers that. Do you think?
And Marion, I kind of, to sort of go off of that, there's a lot of photographers that have approached me recently and saying, I have 50 or 100 photographs.
Mm-hmm.
So, what I tell them is, sure, if you want to publish them in a book or a calendar, a collection of some sort, sure, publish them that way. But if there's one in particular in there that you think is going to be, say, taken out and licensed, just in order to maximize your protection, I think that it's a good idea to consider copyrighting separate ones separately out of that collection. I think that affords you the most protection. What do you, Marion and the gentleman, what do you think of that? Because one lady in particular had one photograph that had been published separately, even been, or that she had put it on Instagram separately from the rest of the collection. And I was
I agree. Part of it is a practical matter too, because when you register, a collective work, there's, and again, a lot of this depends on when it was registered. So in 2020, it looks a whole lot different than it did 10 years ago, when you had to file an amplification statement, basically to break out the individual titles. But just to make it easier to find in the Copyright Office records, I think that makes a lot of sense. If you have something that, is much more commercially viable, I think it's a whole lot easier for someone to be able to find the information, if it's in there separately.
Yeah, I was more comfortable with that, especially given the fact that she was kind of pushing this one image so much more than the other, like couple dozen images in her collection that she, she would market the entire collection, but then there's this other image that she was pushing that was her favorite and had been purchased, in a limited run on T-shirts. That I said, listen, I really think that the prudent way to go about this is this guy separately, even though he's a part of this series. So, I just thought that, given the way she was marketing everything, and I think that's another consideration too, about how, we really have to listen to our clients about how they're intending to use things, in terms of advising them what parts to pull out and copyright separately, or how to copyright it together. So I think that's a very, very crucial practical point.
And also how much money they have, which is
that's another
something I see a lot.
That's definitely another one.
Another registration issue, question that we have here is whether you can download music when you're registering electronically with the Copyright Office. I'm assuming that means, can you, when you're registering your copyright, you would have to upload a portion or a sample. And Marion, you could maybe answer that question better.
Well, I'm not sure that you can do that online. Do you know, Kevin? You probably do that more.
Yeah, the short answer is it's kind of a pain when you're dealing with music, and part of it too. I mean, you have to look at what it is you're actually registering. You're talking about the underlying musical composition or compositions, and the sound recording, or or one or the or both, which you can sometimes do. I have found, just being blunt, most of the time when I'm doing a registration for a client, it's on a completed album anyway. So I've just found it, to be easier from a deposit standpoint. I'm assuming, Robert, I think you're right. That question probably deals with the deposit requirement. And I have frankly found it easier. You can use the electronic Copyright Office system. And there's a way that you can, after you go through the registration, you can actually print a mailing label. And you print it, you put your deposit copies in it. I'm very anal retentive, so I wrap it around there and put multiple, as Robert knows, we used to work together. So I wrap it with multiple rubber bands just to make sure the whole package stays together. And then you send it in. And theoretically, once it gets to the Copyright Office or the Library of Congress, I guess technically, it's supposed to all stay together. And I've just found that to be a much easier way of doing it. And
That's
knock
probably,
on wood, so far I haven't had any issues, but.
That's probably a good idea. I've seen the receiving table.
Yeah.
It's just.
I've seen pictures of the receiving table. I've never been behind the curtain, so.
Yeah.
I believe I saw a question on here regarding a work for hire. I believe it may have been a question involving if the government, Marion mentioned the fact that anything produced by the government would not be copyrightable. So the question was, I believe, and I can't find it now, of course, but if the government hires somebody to produce something for them, would that be still copyrightable for that person who produced it? I don't know of any specific regulations or whatever the statute may be involving government contracts or government hire, but of course, the assumption would be that the person hiring for the, the copyright would belong to the party hiring or hiring for that work. Same for employer or employee. If you're working for somebody and you're producing whatever it may be, copyrightable work, that copyright belongs to the employer. That's why it's very important. It's also important for the employer to have some kind of, if you have a written contract, employment contract with this employee, to set forth in that contract that anything that they produce while they're working for the employer, that work will be, that copyright will belong to the employer. I'm assuming then, and somebody may be able to add to this, is that the government would be the same way, is that if they're hiring for something that they would include in that agreement that whatever that person produces would belong to the government. I don't know if anybody has any more specific information than that.
I would just mention that, the kind of the threshold issue is whether it is or is not a true employment scenario, because absent it being a true employee-employer relationship, under the Copyright Act, there are only certain types of works that can qualify to be works made for hire, which is one reason we generally will use bootstrap language in any agreement, that yes, we agree that it's a work made for hire, however, or a work for hire, however you want to term it. But at any rate, if a court were to decide that it is not, then the author hereby irrevocably transfers or assigns to essentially to the commissioning party.
Very good.
Um,
Go ahead.
I'm sorry, I was just going to address these two questions that came, these bottom two questions, if you don't mind. The copyright violation for the school PTA to show the Disney movie, there was actually a case just like that here recently, that a school did that and Disney did come down on them for it. And I think they ended up paying them, like, what was it, $246 or something like that, as a result of their violation, where they showed, I think it was a movie to a 6th grade class. I can imagine it probably would have been more, the fine probably would have been more if it was shown as a fundraiser, as this question is worded. Is it a copyright violation for a school PTA to show a Disney movie as a fundraiser? I can imagine Disney would have been a lot more aggressive with them if they had actually profited off of it. But as it stood, yeah, it was Disney that came after a school for showing a movie. So yes. And then what about the fact that she posted the one picture on Instagram prior to registration, my client, with the collection? As Marion said, the copyright is implied, so it's implied from day one. However, if she had suffered damages, and Mr. Bandy might be able to speak to or Mr. Levine might be able to speak to this a little bit too. If she had suffered damages, which she doesn't know of, she doesn't think she has as of yet, and she's still trying to decide which, if any, she's going to individually copyright as well, register for copyright protection with the Copyright Office. If she had suffered those damages up until the point that she registered, she would, of course, be limited to, as I said, actual damages and not the statutory damages, of which a much higher cap of $150,000 per violation.
Right. I mean, she would have to, you have to, register your copyright within 3 months of the first publication, or register your copyright, copyrightable work prior to the infringement. So if you register within that 3-month period, you're fine. If the infringement occurs before you register, as long as you register within that 3-month period. But it's imperative that you register before the infringement if it's beyond that 3-month period. The sooner the better, always. Anybody else have anything to add to that? I'm trying to read this last question that popped up. It's kind of a long one. Let me just read it here. It says municipal governments often adopt verbatim copyrighted codes from various groups, i.e. electrical construction or fire codes, as their own code. Take my glasses off even to read it. What rights do the public have to access these codes without paying for the materials from the originating organization?
Mm.
Any thoughts on that?
Well, some of those codes are available online for free. I know you can read them. Fire codes are online and you can read them for free. But a lot of those you have to, go ahead.
Yeah, I was going to say my short answer would be I don't know, but I would go back. I think to the question of whether it's copyrightable, kind of as a threshold question. I mean, it kind of goes back to like it's not truly a directory type of, which obviously directories can be, but I mean, in my mind, I'm not satisfied that it would be, subject to copyright. There again, if it's something that's passed by, some type of a government body, I think you have to get down to the authorship issue. I would think it'd be the government that would own it. How in the world they would police that from a licensing standpoint, I don't know.
Yeah, I mean, some of these trade groups, of course, produce these codes on their own that, their members follow. And then, like, I believe this question is asking is that a lot of these municipal governments will then take those trade codes,
Okay.
those codes from those trade organizations, and then just adopt them. And then once they're put into that, the government code, then of course anybody can access them. But I ran across that at one time, is that when I was looking at some of these, the fire codes, the fire code will reference one of these trade organizations, the codes that they've adopted or prepared. And then I tried to find a copy of that code, of that, that trade organization's code. And then of course you had to pay to get it.
Yeah.
So yeah, I mean, I've run across that before.
So like ASTM standards, the WVU libraries licenses that, but it's only, we have to sign a license agreement. And so we used to get the paper copy and anybody could come in and make a photocopy, for fair use or whatever. But now to use the ASTM standards, you actually have to be a WVU to actually even look at that standard, because we had to sign a license agreement saying that. So they kind of, those societies control that information.
This last question that popped up is a good one. It says, attorney, a brief that an attorney writes and I guess files with the court, whether that's some type of copyrightable work. I know that attorneys are good at taking briefs from in cases that have been, a public record, been filed with the court, and taking those briefs and adapting them or adopting them and putting them in their own briefs. And I believe that's a common thing to do. But whether there's actually a ability to copyright a brief that you file, I don't know the exact answer to that. I would imagine that we've been doing it for so long that you can't copyright it. But
I would go back to whether it's properly cited.
yeah. So I don't know about that one. I know that we do it, and we do it quite often. And I would hate the fact that if somebody wants to use my stuff, then I'd be honored that they do, because I know that I use others as well.
Well, is it part of the public record then? So does the government actually own it then? When you
That's what I
file a
was
brief?
wondering. I think it would, yeah, I think it would be, since it's public record. I mean, that's just what I would, yeah, that would be my concern, is that it's, you know, we've already kind of published it to like almost an open source type of situation.
Right. Right. I mean, if you're producing something for your own, some kind of a presentation that you're going to do or give to a group or something, and you've written something, that would be certainly copyrightable. But filing a brief with the court, I just don't see how that could be. I haven't looked into it.
Very novel question.
That's right. That's right. I'm sure somebody would have found a way of enforcing that by now if they could. So.
Absolutely.
There was another question that had come in some time ago, pretty specific, asking if you're representing an association that hosts conferences for its members, and the conference activities include entertainment like bands. Is it the duty of the association to check whether the venue, such as the hotel or conference center, has a public performance license from ASCAP?
I'll go ahead and jump in. I mean, the short answer is it's the duty of ultimately it's the duty of the venue anytime there's live music being performed, you know, to secure a license. Depending on the type of venue, often that's going to be through a blanket license through ASCAP, BMI, or CSAC in the U.S. Those are the big three U.S. Public performance organizations. I generally, and I've only had this pop up maybe twice in my practice ever. I have always recommended, look, if you're the one essentially who is promoting the show, you know, put it in your agreement with the venue. You know, just shift the burden over and make sure that you're covered contractually. That yes, there is or there will be, you know, a proper license for the public performance in place.
Any subject or topic one of the speakers has that they would like to discuss for the group?
I think we missed one back here. Many artists make multiple paintings of the same subject matter, each with minor variations or of different size. Can each variation be copyrighted even though to most people the paintings look identical?
Mm-hmm.
I think that was there were a couple more that we kind of skipped over too, and we'll try to get back to those. But anyway, Mr. Levine, Mr. Bandy, you guys want to take a crack at that? Because I would think that it would kind of all fall under a series, perhaps, if you were going to do something like that. And then, you know, as I had said, if you had one that was particularly marketable or that you wanted to market, maybe pull it out and register separately.
Well, I mean, each is a separate work. I mean, assuming that each you know meets the threshold that it's, you know, an original you know, expression, then it would be registrable. You know, it's different than you know, making, you know, lithographs or you know, a copy of one work. I mean, just kind of an analogy is, you know, if you're a literary author and you publish a work in 2020 and in 2025 you go in and make a few minor tweaks, you know, there's no question that second work is a new work, even though it's based on the original work or shares, you know, a lot of the, you know, whether it's a derivative or not, but whether it's going to share, you know, most of the same content. So, you know, each should be separately registrable. It's different than if it's just, you know, there's one original and we're just making copies. The copies would not be registrable, but each original, you know, expression would be.
Right. If you would ask the artist would definitely tell you that each time they painted it, it would be a different work, even though it may look similar. The fact that they painted a new painting would be a separate and distinct work. So. There is a question here, and I did miss. It says, a friend and I designed a plaque in honor of my uncle killed in the Great War and had it erected in France. Is the design protected? And who does the design belong to? To my friend, to me, or both? So this is a design of a plaque.
Mhm.
Anybody want to chime in
Well,
on that?
Sculpture is, and you know, to another separate topic, of course, is architectural blueprints. That, I mean, works of art that are 3D are of course also copyrightable. So, I mean, I think that it would be, you know, copyrightable as a sculpture, a work of art that way, even though it doesn't have any type of verbal, you know, component to it or anything else. Sure, it's still a work of art and it's still copyrightable. The fact that it's in France, of course, the World Intellectual Property Organization is a division of the World Trade Commission, and you would have to look at the World Intellectual Property Organization, or WIPO, W-I-P-O, of which the United States and France are both members, for some guidance there regarding French law.
Well, this also brings up a question too, is that you say you and your friend created it. And if
Right.
you wanted to pursue an interest, do you have a contract between the two of you sharing interest? We see this with students a lot. They have this great idea and they're doing it together, and then there's no agreement to who owns what. So.
Somebody posted here after our discussion about legal briefs that in 2014, a district court held that one could copyright a legal brief, but the legal publishers had a right of fair use due to, in part, the filing of them with the court. Now, of course, that's involving legal publishers like, I guess, Westlaw or Lexis, where they post briefs on their site that you can download or access. How about somebody, an attorney, then taking a part of that brief and incorporate it in their brief? Would that be fair use, or is that just considered plagiarism? And again, I know that it's a common practice for attorneys to go on to Westlaw or Lexis and find briefs, and not to reinvent the wheel, just to go ahead and incorporate somebody else's arguments in their own brief. A good question, but probably no clear answer at this point. Kevin, looks like there's a music question that just popped up. The client wrote song, both lyrics and music, and a nationally recognized band is interested in the song. He doesn't write or read music, so if he doesn't submit the song, he could only submit lyrics. Or does he submit a recording?
From a registration, okay, bear with me. I'm pulling it up right now in the chat just to make sure I understand the question. Yeah, I mean, without going into the minutia details as to the best copy and all that, as a practical matter, generally a work tape is what would get registered. You know, if you're the composer or the songwriter, you could register the simple guitar or piano and vocal. What we just call a work tape, basically, evidencing what you have written at that time. And that would be suitable, as long as you're able to actually perceive, the work from there. You wouldn't have to, the client would not have to hire, someone to actually transcribe it into notation or any of that.
I know that Marion mentioned in her presentation the Digital Millennium Copyright Act. Wanted to, and it just reminded me that a couple things I wanted to stress on that. Of course, one of the key aspects of that act is that it provides some protection to the sites that post or actually offer a site for others to post on. So if somebody else is posting photographs or whatever the case may be, songs or something, it offers some protection to the site from liability for those people who are posting this material, who are posting or infringing upon somebody else's copyright. However, one of the key things on that act as well is that you have to post, you have to have on your site a notice to individuals that if there's something on their site that is a violation of their copyright, it gives them an opportunity and a means, a procedure to then contact you and inform you that there is something on that site that is in violation of their copyright, and give them an opportunity to then take that material down. So, you know, if you have a site that you allow other people to post on, you have to comply with the act in order to receive the benefits of that act and that safe harbor. So I don't know if anybody has anything to add to that act. And Kevin, have you had any experience, or Michael, with clients that may be offering a site for others to post on?
No, I haven't. Go ahead. I'm sorry. Go ahead, Mr. Levine.
I was going to say the only experience I've had is the opposite end when you know, if people are claiming infringement and they have to send a DMCA notice, but not representing the actual, you know, provider.
So when you have a client that they notice something on one of these websites, you know, YouTube or even Facebook, I guess, that, hey, my work is on there. What kind of procedure do you follow in order to try to protect that client's rights? Kevin?
Yeah, well, it's generally just sending that statutory DMCA notice to the designated agent, and it's I mean, it's a relatively straightforward notice that you send, and in my experience, generally speaking, they're pretty responsive, because, you know, they don't want to lose that safe harbor protection as a, you know, as a provider. So they with a few exceptions, they tend to be pretty proactive, you know, as far as after they receive that notice.
So what's the liability on their part if they don't act? I'm assuming there's a, and I haven't looked specifically at the requirements under the act, but I'm assuming there's a time frame that they have to respond or to take down whatever the infringing material is.
It's been ages since I've actually had to look at the language of the act. I mean, it's generally just a matter of sending out the notice. But I mean, it's, you know, the DMCA, it's the meat of it is being able to avail yourself of that safe harbor provision, so that, you know, you're able to carve out and say, hey, it's not us, it's you know, it's the user who put that content on here. And if you lose that, you know, that can be pretty devastating as a provider.
Right.
I know that YouTube has like a takedown notice, and then you can object to the takedown notice and give your reasonings why it should be there or not. Could look at the content provider and see what the notices are there too.
Right. You know, like I said before, I mean, they definitely have to have that procedure and have it posted on their site, that, so it should be able, you should be able to find it, and it should be clear as to what you need to do in order to inform them of that infringing work. Marion also mentioned in her presentation regarding the trade secrets. I don't think, some people may not think of trade secrets as being a part of their intellectual property portfolio, but it's definitely something that businesses need to think about. Of course, the key thing about trade secret is that you want to keep it secret. So if it gets out there, it could definitely hurt your business. And there is the Defend Trade Secrets Act. The Defend Trade Secrets Act is implemented in 2016 as, for the federal aspect. I believe each state has a version of the Defend Trade Secrets Act. I know that West Virginia does. But the federal statute, of course, allows for a federal claim, allows you to get into federal court. A lot of the clients usually come forward and want to be in federal court rather than state court for various reasons. So there is a form of the Defend Trade Secrets Act that's a federal statute that allows you to go to federal court. So one of the key things about the federal version is that they have an ex parte seizure provision in that statute. So if you have trade secrets that are being misappropriated, you can seek from the court ex parte a order that seizes that material. Of course, there are elements that you need to satisfy. One, that a normal injunctive proceeding is not sufficient, that that person has misappropriated, of course, that they're going to use it, or to not likely to comply with an injunctive order. So it's imperative that you seize the material, and that you have to show that you are likely to succeed in your suit for misappropriation of that trade secret. So that's one of the key things of the federal version, is that you have that mechanism that you can try to seize that material and get it back. Usually you're involving, you have a former employee that has left your employment and has now misappropriated or taken those trade secrets and is using them in his new employment or her new employment. So one of the things is that if the employee leaves with that trade secret on their computer, whatever that trade secret may be, and you need to get that material back, so that ex parte seizure procedure is key in order to get that, actual physical computer or whatever software, whatever the case may be, actually get that back and prevent the dissemination of that material information. So that was one of the things that I was thinking about during Marion's presentation. I was going to bring up. So I don't know if any of the others have any experience with the Defend Trade Secrets Act. Kevin, Michael?
Not, I deal with trade secrets quite a bit, but I have not had anything of the Trade Secrets Act since its inception.
Same here.
I was just thinking about client lists are a big part of a trade secret, and I recently was reading something about how that's why different companies even own the phones that their employees use, so that when they leave the business, then they have all the contacts from the phone, because the client list can be a very important trade secret.
Right, and it's key in your employment contracts, perhaps to have information in that contract that says that this information is to be kept, private, secret. One of the elements of the act is that you have to actively try to keep this information secret. You can't be just putting it out there without any type of, I guess, indication that it is to be kept secret. And there are, of course, requirements in any type of employment agreement for whistleblowers. One of the key things, in order to have the rights under this Trade Secrets Act, that you have to have in your agreement a notice to the employer or employee that they have a right, that they're not going to be prosecuted or liable for providing that information to a government organization or to prosecuting prosecutor or whatever, if you're doing that because of a whistleblower aspect.
One thing I would mention, Robert, just as kind of general, just a general thought on trade secrets, if it's, there seems to be kind of the knee-jerk reaction among entrepreneurs that, okay, I've got this novel idea for a new invention or whatever it is that's subject to patent, and they think, oh, well, I've got to get a patent on this. I got to go get a patent, and just in particularly for any business lawyers who are on here that don't practice intellectual property. I mean, I know that I'm not a patent lawyer. Let me mention that, but I know a lot of patent lawyers and deal with a lot of them. And, I think most patent lawyers understand this, certainly, but there are many times that, trade, you really need to consider, is this particular item, better suited to trade secret protection, not only from the standpoint that, that's really your default position from the beginning, assuming you haven't, blabbed about, building the better mousetrap online and the cat's out of the bag already. But in many cases, you're able to really maximize your income as the inventor by by utilizing trade secret, rather than going through patent, not only the expense aspect, but just the standpoint that the life of a patent is pretty limited. I mean, I always go to Coca-Cola. I mean, how much money would they have lost had they gone the patent route rather than the trade secret route? All these many decades later, it's still a closely guarded secret. And obviously, a lot of it depends on the work itself. I mean, if it's something that is easily reverse engineered, yeah, patent is probably the way to go rather than a trade secret. But if it's something again like the Coca-Cola formula that so far no one's figured it out, or at least if they have, they're not saying anything. There's just the longevity aspect, from commercialization. Making a trade secret route, I think, makes a lot more sense. And it's just, again, I know this is a long way of saying, don't overlook, whether trade secret is a better way to go than patent. As if you're representing inventors or those folks.
If I can jump in here, I'm actually a registered patent attorney. The other thing you're going to want to consider with patents, like you said, versus trade secrets, is that a patent, I mean, they publish it, your whole patent, everything you submit to the patent office regarding that, the way that your invention works, that's all published 18 months after the application. So, like Mr. Levine is saying, with a trade secret, you get a lot more protection for the secret itself, obviously, with trade secrets. Now, if you're wanting to license and market your invention, obviously it's more valuable if it's patented. But if your company is doing something just based on the secret, their secret sauce, their Coca-Cola formula, you're going to want to take, at least advise to take a hard look at the trade secret route, like Mr. Levine said, because you have that publication with a patent that, I mean, it happens unless it's scooped up by the government with a secrecy order.
Yeah, the key with the trade secret, of course, is to keep it secret. So you have to really have some procedures to make sure that is kept a secret. Limited disclose, who you're going to disclose that to, and make sure it's limited to the scope that you can keep it secret and not have it misappropriated.
You have to have that conversation with your client early that it's cheap, but it's not free. And just calling it a trade secret, that's one thing, but you actually have to put practice behind that. And so.
Well, it is 10:51. Do we want to take a break now until 11 o'clock?
Yes, let's do that. I think we've covered all of the questions that came in. Thank you for that wide variety of questions and all of those answers and input from our speakers. Before we do go to the break, just in case anybody missed the initial announcements, if you logged on late, this CLE course is worth 3 CLE credits. If you are registered for the course, you will be sent an email from Mike Mellis that has the links for reporting your credit. There was a question somewhere early on, I guess 2 attorneys are watching the same screen. Whoever is registered is the one that's going to receive those links. So if there's somebody else that is watching, you can self-report those credits, but everybody that was registered should wait to get that email and not self-report them, because it'll cause a duplication of credit if you both confirm the email and self-report the credits. Again, be watching for that email probably sometime tomorrow that has the links for the credits. And if you don't receive the email and you were registered, be sure to check your spam to see if that email went to your spam account. So with that, we'll take a break until 11 o'clock and come back for our final presentation from Michael Bennett. Thanks.
Thank you.
Thank you very much.
Thank you.
Thanks.
Is Mike or Angie? This is Michael Ellen. Are you standing by?
Yeah, I'm here.
Okay, I'm trying to get my presentation up to do the screen share with.
Let me run and go get Mike because that's more his
Okay,
work than mine. Just 1 second. He's close.
okay. Even Marion, if Marion happens to know.
It's at the bottom of your screen. It's a green button, like you got to move your mouse down and then the control bar comes up.
Right. Well, no, after I pull the presentation to the, after I pull it up though, yeah, I see this screen, the share screen option, but
That's
Yeah,
what
you know,
then-
after I get it,
you need to do the share screen.
okay. But if I do that, oh, okay, all right, gotcha. Okay, I do that first. Okay, all right,
And
I
then-
see what Marion was saying now. Gotcha.
And then you have to pick which screen you're sharing.
Right. Okay, there it is. And then
Oh, yeah, right there.
hopefully,
I see it.
There you go.
I hope it's in presentation mode. There it is, I hope.
Perfect.
You're on.
Okay,
Looks good.
good stuff. Thank you. Thank you guys. Marion, Mike, thank you guys.
You're welcome.
All right. Well, it is right about 11 o'clock, so we'll get started as scheduled. So, Michael, I'll turn it over to you.
Okay, thank you very much, Angie. This is definitely a team effort here, doing this presentation remotely. And I'd like to thank my fellow presenters and panelists for their flexibility with this, because this was obviously an unforeseen circumstance. We were planning on all of us being there at the Barr Center with you. So I'd like to thank everybody for attending virtually, and thank especially my presenters and panelists for coordinating this to be a virtual presentation. And with that being said, let's get into the third hour of our continuing legal education class, and that is me. I'm Michael Ellen Suzuki Bennett, and I am a registered patent attorney, as I said at the panel, and I'm going to be discussing how to get registered as a patent attorney with the U.S. Patent and Trademark Office. It is a process, and whoops, I don't know if I can go back or not. Anyway, previous slide simply said that there are what we will cover in this hour, and that's qualifications to sit for the patent bar exam, eligibility to get registered for the patent before the Patent and Trademark Office, educational requirements, and the patent bar exam itself. So that's kind of broken down into those. Now this particular slide shows data through the year 2018, and as you can see, that patent filings had been on the rise in the United States, except for just a little bit of hiccup / stability there between 2017 and 2018. That's the last year for which statistics are available. But given this new era that we're in, and the phrase necessity is the mother of invention, which is an old English saying, you know, I don't know what we're about to see in terms of patent filing, because you've got all these people at home, homeschooling their children, is digital media, and you know, I just don't know what we're getting ready to see, frankly, with this new environment, with the coronavirus and quarantine and things like that. Is this our new normal? And if so, I'd say we're getting ready to see, you know, a boom in, you know, in people with their inventions and intellectual property. So that being the case, these statistics are taken from the World Intellectual Property Organization that I had referenced earlier. And these are patent applications in the United States by residents and non-residents, and applications received from abroad. So you can tell that they're about even with the non-residents, edging the residents just a bit. You know, so if you're registered to practice before the U.S. Patent and Trademark Office, that registration is good globally. So I can be in Bora Bora and filing my patents for my clients, which, you know, hey, let's face it, that's the goal, right? So, you know, that's, if you're registered before the U.S. Patent and Trademark Office, you have to be a citizen or registered with a state bar, a United States state bar, but we'll cover that in a moment. The USPTO requirements for registration are 43 short pages, or you can hang out with me for the next 50 minutes, or actually I guess it's about 45. So there is a link within my presentation that is a hyperlink to the actual 43-page document. And if you are sitting for the patent bar exam or even considering it, I highly advise that you make this link right here your Bible. It lays out everything, and it's what the patent office goes by. They will refer to it, excuse me, they will refer to it when they are discussing things with you. They'll say, oh, well, that's on page 5 of, that's what they mean. This is their Bible. So if you're considering it, you just want to take a look through it, click on this link right here, or just Google, you know, USPTO or patent bar exam qualification or eligibility, and that will take you right to it. Believe me, there's only one. So the eligibility requirements, as I said, you must have a law license in any U.S. state or in D.C. The educational requirements must be met, and we'll discuss those at length here in a moment. And you must prove to the director's satisfaction that you're reformed if any of the following apply to you: a previous felony conviction or a plea to a felony, you've been disbarred by any profession, not just law, but say medicine, for 5 years or more, or if you've previously been denied admission to the USPTO for lack of good character. So the educational requirements, these are what prevent a lot of people from pursuing this. There are 3 different categories that you can pursue, 3 different avenues by which you can meet these educational requirements, and they are a degree in an approved field, hours in approved fields, or one approved field, which we'll talk about in a second, or category C, which is practical engineering or scientific experience. And the language that they use throughout the manual is you must prove to the satisfaction of the director, and they really lay out very detailed in categories A and B how that's done. Some things are given more guidance than others. So basically, category A, the approved degree. You have your physical sciences, biology, biochemistry, botany, computer science is a bit different. That's actually, you're going to want to read more about the computer science requirements if you do choose to do computer science, general chemistry, microbiology, organic chemistry, and then you've got your engineering. Most of your engineerings are on there, but if it's not, you're going to probably want to take a look at another category. Say you have a graduate degree in an approved field. You would think, hey, if I've got a graduate degree in it, that's better than having an undergraduate degree in it. Not really. The approved degree on the previous page, I'm sorry, I meant to mention, those are bachelor's degrees. You're going to have just bachelor's degrees for those. Graduate degrees are not the same. They're not treated the same by the patent office. If you have an undergraduate degree in political science and a graduate degree in biology, you're still just treated as not having that approved Category A degree. So a graduate degree or any type of special certification over and above your undergraduate degree in those approved fields is not necessarily dispositive if you don't have that graduate degree or that undergraduate degree. So Category B, and also you might want to note that what's not on the Category A, nursing and mathematics and things of that nature are not included with Category A either. You're going to want to look, if you have those degrees, you're going to want to look here to Category B, which are your approved hours. Now, there's several different ways that you can kind of cobble these hours together. Then there's two different ways, which I'll talk about in a moment, of getting, of ascertaining whether or not your hours count. Option one is 24 semester hours in physics, with the caveat that only physics courses for the physics majors will be accepted. So if you have taken a course that's like physics for nurses or biophysics for medicine or something titled to that effect, unless it counts as elective credit hours towards a physics bachelor's degree at that school, and the school is accredited, it will not count toward this 24 semester hours in physics. Now, I know that doesn't make a whole lot of sense when you're talking about something like biophysics in medical school, but if that class did not count as elective hours for the physics major, you can't count them toward the 24 hours. So that is the easiest and quickest route, is the 24 semester hours in physics for the physics major. Say you don't have the degree in physics, you finished a semester, you stopped the semester short of your physics degree, but you have the 24 hours toward the major, you're eligible under Category B, option one, check. That's the easy way. Option two is the 32 semester hours in a combination of the following. So you have your 8 semester hours in chemistry or physics and 24 semester hours in biology, botany, microbiology, or molecular biology. The trick with the 8 hours in chemistry and physics, excuse me, is that they must be consecutive and they must count toward the major. The quickest way to do that is like a Principles of Chemistry or a Principles of Physics series, like Principles 1 and Principles 2. People who start out majoring in biology in undergraduate school, for instance, are probably going to take that Principles of Chemistry 1 and 2, and maybe even the Principles of Physics 1 and 2 your first year. Since it is 8 hours, and I believe they have to have laboratory with them. So 4 hours of a lecture of both may not get you there. I'm not sure under the new guidelines. I know under the old ones it had to be a laboratory course. The physics and the chemistry, the general chemistry, or even something titled Chemistry for Nurses or Chemistry for Teachers, you know, there's classes that are geared specifically toward one profession or another. Those are not counted as approved by the USPTO because they wouldn't count as elective hours to transfer into a chemistry degree or a biology degree. Even if they did transfer into that, you would be in kind of a fight with the USPTO to get those to count. One easy way to see with chemistry, if you do have something like Chemistry for Nurses 1, and then you took Organic 1 and 2 your sophomore year, let's say, then the organic class, Organic 1 and Organic 2, because those could be used either for your nursing degree or if you switched majors and now, or your teaching degree, and then you switch majors and you're now majoring in something else, those Organic 1 and Organic 2 could even meet that requirement for the 8 semester hours of chemistry. requirement for option 2 or subsequent options that we're going to talk about. The 24 semester hours in biology, botany, microbiology, or molecular biology, you want to be very careful there because it can be a little bit misleading when it says botany here, because botany classes are not counted toward the biology hours that are required unless they are for the biology major. Botany and ecology classes must be available as elective classes in that degree, for that degree, at that accredited institution to be counted as towards your 24 hours in biology for option 2. So option 2, 8 consecutive semester hours, chemistry or physics, and 24 in one of the biological sciences. That counts toward a major in those degrees at that accredited institution. So that's option 2. Option 3 is a bit more like option 1. It's pretty straightforward, but a little bit more stringent in the hours. That's 30 semester hours in chemistry. And again, only chemistry courses for the major will be accepted. So if you have that general chemistry 1 or 2, or chemistry for teachers 1 and 2, for education majors 1 and 2, and then you went and took your organic classes, and then you went on and took other subsequent chemistry classes, just bear in mind that that general chemistry class that you took that first year, the chemistry for teachers or chemistry for nursing, those classes, unless they count as elective hours toward that chemistry major at your institution, they're not going to count toward this 30 hours for chemistry for the USPTO. The director absolutely will not count those hours. So when you're going through and counting up your hours, please bear that in mind, that it needs to be like a principles of chemistry for the major, like the first classes in the sequence that a major would have taken, a major in biology or chemistry or physics if you're going the physics route. So there's that too. So that caveat applies to the 30 semester hours of chemistry for option 3. Option 4 is a bit more scattershot, and it's a little bit trickier. That's 40 total semester hours in a combination of the following. 8 semester hours in chemistry, or 8 in physics. So again, that's like option 2, what we discussed there. They're going to need to be consecutive classes, and they're going to need to be the ones for the major. And again, you can use organic 1 and organic 2 to satisfy that for the chemistry part of it. And 32 semester hours of, and this is an or, so of the following: 32 in chemistry, physics, biology, botany, microbiology, molecular biology, or engineering. So 32 total. If you add all those up and say you majored in biology for 2 years and then switched to engineering, you're probably going to go ahead and have enough hours under the biology, microbiology, engineering, things like that. So that's 32 semester hours, and the sticking point with that is they must count toward those majors. Even the engineering, so if they don't count toward an engineering degree at that school, that is, they're not going to count toward the major at the, they're not going to count toward the 32 hours for the USPTO. Now, I know that it can be intimidating, or you can sit down and you can say objectively, oh, sure, I have 24 semester hours in physics. I majored in that for a couple of years, and here's the classes. And you can go over your transcript and pick them off and add them up and say, hey, actually, it turns out I have 26. And you think in your head, you're good to go. The USPTO may not see it that way. You gather up all of your information, you send it in, and you get a letter back that says, actually, you don't. We're only going to count 22 of those hours. This 1 4-hour class that you had counted in your head isn't going to count by us. That can be pretty common That's my understanding of it when I went through the application process. It's been over 10 years ago, and that's why you have this manual, this 43-page Bible, or people like me that you can email or call and say, hey, you know, how do you go about this? Well, when you're adding up your hours, there's either the way to go that you look at it of are these classes counted toward the major at this school? And you can just kind of wing it on your own and do it on your own. And that's what I did. Or there's the way that my friend Sarah did it. And she actually was going for I believe it was the engineering courses down here under option 4. And she was very worried about which engineering courses they would or would not accept towards the 32 semester hours. So what she did, and again, this was about a dozen years ago, she got all of her things together, knowing that she had only about, I think it was 18 semester hours of engineering at the time. She had the 8 of chemistry, or the 8 of physics, and she sent everything in. She gathered up all of the information, which we'll discuss here in a few minutes, and sent it all in. And they sent her a letter back that said, you know, while you only have 18 hours of engineering, please see the following courses that you might take. And they gave her a list of possible courses that she might take. So she was able to find those courses and take those and get qualified to sit for the patent bar under option 4. I did mine under option 2, which was the 32 hours. I had the chemistry and the chemistry and the biology/biochemistry. Really for purposes of the patent office, even though they are 2 separate and distinct fields, microbiology or molecular biology is different than biochemistry. But because of my chemistry background, because of the way that the classes overlap, my chemistry hours actually counted as microbiology, molecular biology hours. So that was the way that I did it. And again, I had more than enough hours. I had about an 8-hour cushion built in there when I went to apply under option 2, but my friend Sarah did option 4, didn't have enough hours, knew she didn't have enough hours, and so sent her application in, knowing that she didn't have enough, and got some guidance back from them on what to take. The only drawback to doing that is it costs $400 to send that application in, and that's a non-refundable fee. So if you have $400 that you would like to invest in the chance that they might give you the same kind of detailed information back, absolutely, that's a good way to go about it. If you have an excess, or you're pretty sure you have an excess of hours in one of these fields that counts toward the major in those fields at an accredited institution, go ahead and send it in. And, you know, especially if you have a bit of a cushion there, go ahead and send that in, and you can be eligible under whichever option you have the most hours in. So there's 2 ways to do that, and these are the options that you can pursue. Okay, so yes, under option 4, there are some limitations as to what engineering courses and computer courses are going to be. And this is language straight from the Bible, the 43-page USPTO manual. The only classes that emphasize certain areas of an art is what the term the patent office uses. You know, the field is the art. Only certain classes are going to count toward that. And really what they're looking for with these classes, the overarching theme is practical, hands-on experience or knowledge, being taught in the classes. So if you're going under engineering or drafting, your computer science courses, you're going to want to take a very tough look at the qualifications for those courses under option 4. And again, there's no substitute for the 8 semester hours of chemistry or physics under option 4. When it says that you have to have the 8 semester hours in chemistry or physics, but you say, oh, but I have, 40 in biology and for the physics major, but they're not in sequence. And it's like, well, that's probably not going to be enough. The 40 in biology surely won't be enough unless there's 2 in that, of that 40, 2 of those classes from those 40 hours were in chemistry or physics sequential classes. They will give you a hard time about that. Now for transcripts. You're definitely going to have to submit these from each institution that you're counting classes from. Not necessarily, it may not be the institution that you graduated from, but if you did, say, 2 years of a biochemistry major at one school, and then you ended up transferring to another school and finishing up in poli-sci or business administration, you're going to need the transcript, and the things that they're going to look at are going to be from that first school. So you're going to need official transcripts, and by that they mean the raised seal transcripts that you get from the registrar's office. Copies are not going to be sufficient unless it's issued to you from an official copy from the registrar. The grades have to be a C- or above to count toward those hours total. So if you have a D in a course, that even though it counts toward the, say, the biology major, it's not going to count that course if it's 3 hours or 4 hours. Those hours credit are not going to count toward your overall number of hours to get registered under one of the options for category B. These transcripts that you're going to submit do need to show the same name as your USPTO application. Now this is mostly ladies, but I don't know, some gentlemen too. If you have gotten married and or otherwise, or divorced or otherwise changed your name, you need to submit an official document such as your marriage certificate or divorce decree that reflects that difference. So that's another little snag in there that we ladies get to deal with when we get married. Having the universities themselves mail the transcripts directly to the patent office is going to create a bit of extra work for everybody, because they then have to go match it up with your, and I'm here to tell you the patent office does not like extra work. They're going to have to go match it up with your application. It's just easier to go ahead and pay that fee and get those transcripts sent directly to you from the school, put them all together, and submit a nice, neat application. There are other factors and other training that are listed in this 43-page manual that might qualify you based on your education to sit for the patent bar exam. They literally say, this language is directly from the Bible, the patent Bible. Other factors will be considered on a case-by-case basis with respect to scientific and technical training. Great, you say, what other factors? They don't tell you. So it's one of those situations where you probably going to want to avoid that route and go some other route if you have enough hours to put together one of the options in category B. That's really the easiest way to go. Other education, including like from a foreign, an overseas or Canadian or Mexican school or other sort of institution, work experience, military education is acceptable to the extent that it objective evidence demonstrates the education is equivalent to that received at an accredited U.S. college or institution or university in one of the subject areas listed in category A. So, what is not acceptable? The main ones you're going to want to watch out for here, I think I've highlighted them. Unfortunately, military service is listed explicitly as not acceptable. So if you have, 2 years working with the Army Corps of Engineers, but you don't have enough engineering credits to qualify under option B, unfortunately, they're not going to consider that military service prima facie evidence that you're qualified and you're going to have to go under the other experience category, it's way more amorphous in general than if you just had X amount of credit hours that they could go through. Courses in the following areas, and again, there's a ton of them there. Some of these you would be thinking, now wait a minute, especially with astronomy, for instance, some astronomy courses are very high level physics courses. They're very math oriented. Those will probably count if they're the high level physics courses that you could use as elective hours towards the physics major. So watch out there. But generally people think, oh, I had physics, whatever it is, 032 at WVU my freshman year. That's 3 hours of physics or 4 hours of physics. And it was the astronomy course. General astronomy courses that don't count as elective hours toward the major will not be counted, even though they have that physics designation and they're taught by the physics department. If they don't count toward the major, you're not going to be able to count them as physics hours. Same with ecology. Even though they are counted toward a biology, or even though they're taught by the biology department, unless the general ecology class is like a principles of ecology, which is 3 hours that could count toward the biology major, elective hours toward the biology major, they're not going to count that either. Same principle applies as to the astronomy courses. Now, with all of this focus on math and science and practical and technical training, you would think that math courses would count. However, they do not. Also, any type of history of engineering, science, technology, things like that, they will not. The field identification of plants or animals, and that's what I said to watch out for with the botany classes. Even though they list botany specifically under category B, a couple of the options specifically and clearly state that botany classes will count. If they're merely classes on the field identification of plants and or animals, they will not count. They need to contain more, and I hate to use just the general term of science to them, but they need to be more of a chemistry-oriented type of class. If it's not just field identification, but if it's collecting samples that you then have to take back to the lab and run through an HPLC or an electrophoresis gel or something like that, that's more likely to be hours that might count toward a major versus just simply picking up a leaf and being able to identify that that's a maple or that's an oak. Those field identification courses are not going to count toward your hours for the patent office, but your higher level ones that would count as your 3 elective hours, of course, those are. Same with paleontology. If it counts as a biology class, if it's a biology class of a junior or senior level, like molecular paleontology is a very good example of something that, even though it's paleontology and they probably would be inclined to dismiss it, if it's a 3-hour course of molecular paleontology and you studied laboratory techniques and identifications and you had chemistry prerequisites to get into the class and things like that, and it counted as those hours towards the elective credits that you could count toward a biology major, you're probably okay. And again, the big one, science courses for non-science majors. So as I said, principles of engineering or principles of chemistry for educators or principles of chemistry for nurses. Those are looked at differently than principles of biology or principles of chemistry that would count as your first year course in the major. So you're just going to want to watch out for those. Category C is engineering or experience. The technical training can be illustrated by passing the fundamentals of engineering test. And that is a test administered by each state. More information and registration for the test can be found at the Secretary of State's office or the board that governs them in each state. The West Virginia State Board of Registration for Professional Engineers can be found at the following link. And I'm sorry, I don't think that's a hyperlink, but if you want to check it out, it's www.wvpe.edu. B as in boy, D as in dog.org. And you can find out how you can get registered to sit for the Fundamentals of Engineering exam, to qualify under Category C for Engineering and Experience, to sit for the Patent Bar exam at that website. And if you're in Tennessee, check out the Tennessee Board for the Registration of Professional Engineers, or the equivalent organization in your state. So, great, you're satisfactorily educated. Now what? The Patent Bar exam itself. The overall pass rate is usually somewhere around above the 40% mark. Now that's an aggregate pass rate for both first-time and repeat test takers. First-time pass rates are usually hover below the 40% mark. Don't let that scare you. It is a computerized, standardized test, so it's multiple choice. Each answer is about a paragraph. So it's like the LSAT or some law school exams. It is largely a reading test, sports fans. It is largely a reading test. You will be given a copy of the Manual of Patent Examining Procedure, or MPEP, a digital copy, and it's searchable. Now, with which to take this standardized test. Now, my mother and father, a nurse and a dentist, told me when I was in about the 2nd grade to always watch out for an open book test. They said, you'll think that you don't need to study for it, when in reality, they're actually the hardest ones offered. And I thought they were crazy. You know, with me, with all of my worldly knowledge at 7, I thought that, oh, that's just nuts. It must have changed since the olden days when they took the test. No, it hasn't. It is the MPEP. Don't let that lull you into a false sense of security. You need to be familiar with the MPEP, know what's in it, know the table of contents forward and backwards, and excuse me, even though it is there to search, spend as little time searching it as you absolutely have to. The key to studying for the Patent Bar exam is old tests. When I took the Patent Bar exam 12 years ago, yes, 12 years ago, or was it 13 years ago? 12 years ago, I believe. So I'm old, I can't remember. So about a dozen years ago, about 70, they said going into it, about 75% of the questions were from previous exams. That's not a lie, verbatim from previous exams. So if you know those old exams and you know those answers to those old questions, you're going to get the required pass rate almost exclusively off of those old exams. Know them forward and backwards. The bulk of your study time, the best way to study is those old exams. And then they, like the bar exam questions, they also offer the rationale for the answers at the end of the exams. Know those old exams, know why they got those answers, how they got those answers, because if they are not verbatim, they'll like change one name. You know, company A will become company 1 in the new question, but it's the same exact fact pattern, and you'll recognize it right off the top of your head. If you've studied those old exams, they're the best way to study, best possible way to study. Excuse me. And the newer questions are really more rearrangements of fact patterns or things perhaps that have been in the news recently, things like that. So those are your best bets for studying. But know that MPEP. It's not possible to know the entire thing. The entire MPEP is a couple thousand pages. It's not possible to memorize the entire thing, or really, I don't even know who would want to read the entire thing. But really, the tables of contents are where you're going to want to spend the bulk of your time in the MPEP when you're studying for the Patent Bar exam. So if you have any questions about any of this, you can email me here at mebennett@kincaidandassociates.com. You can also check out our website at www.kincaidandassociates.com. Give me a call at 866-435-5971. And again, I'm with Kincaid and Associates. My name is Michael Ellen Bennett. I'm registered to practice in West Virginia. And Kincaid and Associates is based in North Carolina. And we have offices in Wilmington, North Carolina, which is where I live. That's where I'm based. But we also have offices in Raleigh, North Carolina, in Asheville, North Carolina, and in Charlotte, North Carolina. Now, I'm primarily based in the Wilmington office right now. I'd be happy to do a video conference with anybody. I simply can't do the video conferencing and have my computer screen share up today because of the limitations of the technology that I'm working with. My desktop is actually remote, so I can't, the camera won't work on it to actually guide the camera that's on my laptop. But I could do a video conference with you if you would prefer to do a video conference. I can always do a conference call with you, and or of course you can email me or just call me, and I'd be happy to talk through any of this or any other aspects of patent law with you. And that's about it. So see if I can get this. I don't know if I can get this off of here. And I will take some questions now. I can't see the Zoom presentation to see if anybody has questions.
I haven't seen any come through on the chat feature.
Okay, I can't seem to get back to the Zoom screen here. Okay, as the shared window is closed. Okay. Okay. Oh, okay. I hope that that's off of. I see video conference there on the intro feed there. So if anybody has any questions, you do need to be registered before the United States Patent and Trademark Office, of course, to file a patent. Other attorneys do file trademarks, and of course, copyrights are totally separate, and trade secrets are not, you don't have to be a registered patent attorney to file those. But to file a patent, you do need to be a registered patent attorney. And one thing I would like to mention very briefly is the issue of patent agents. A patent agent is somebody that will help you prepare a patent application that is, they're not a patent attorney, but they have those educational requirements, and they have also qualified for in the exact same way, minus the law degree, sat for and passed the exact same patent bar exam as a patent attorney. And those patent agents are qualified, and a lot of firms do in fact employ them as patent agents to help folks draft those patent applications and to file them with the USPTO and represent clients before the USPTO. And the patent agent can assist clients in regular patent prosecution that goes off without a hitch. That person is skilled, has demonstrated by virtue of a degree or virtue of their education, under Category B or Category C, their engineering or practical knowledge by passing that Fundamentals of Engineering exam. They've demonstrated the requisite level of expertise in that particular art, meaning chemistry or physics or engineering, that they have enough knowledge to represent somebody prosecuting a patent application and deal with the patent examiner and the patent office through the application process, provided that no legal issue comes up. If a legal issue arises in somebody's patent application, the patent office is likely to go back and tell that person that they need to hire specifically a patent attorney. So at that point, you will need a patent attorney involved. But prior to that, if you don't have a law degree and you otherwise qualify to sit for and pass the patent examination, you can become a patent agent, a registered patent agent. So there is that possible career route as well.
Michael, we did have one question that came in asking if you can ballpark the cost of applying for a patent.
Right, and I'm going to give the typical law school answer there of it depends. I'm really sorry to do that, but there are different ways that you could save your clients a lot of money with patent prosecution in terms of the fees that the patent office is paid. Of course, each individual attorney is going to set their own rate. Now, with my firm, we like to try to really promote small business. We try to keep our rates extremely competitive, keep it affordable for the small business, the small inventor, the garage inventor, as they're called, because we believe that small businesses really do drive the economy. So I'm sorry if you hear my dog in the background. She's sitting right on my arm and seems to want attention. But anyway, so the ballpark cost for applying for a patent is that you're going to want to look at, does your client qualify as a micro entity, or do they get a small business discount? And the micro entity status is generally an employee, a company that employs less than 50 people, and you can qualify for a discount of up to 90% off of the patent office fees. So, and some filings might just be free for you to file as a micro entity status. So you're definitely going to want to take a look. Like Procter & Gamble, for instance, would obviously be paying the full price, but a garage inventor, again, keeping the cost low to promote small business, the garage inventor, the mom and pop store, folks like that are going to have a lower cost to overall to file and to maintain that patent. Anything else?
I haven't seen any other questions come in.
Okay. All right, well, that's the basic process of applying for and becoming a registered patent attorney. Or, like I said, same things apply, only if you don't have a law degree, you can become a registered patent agent and assist people that way too. And, law firms employ patent agents, companies employ patent agents, private companies employ them, all kinds of career options there. And if you have any questions, just give me a call.
All right, if there's no further questions, sorry, I might have cut somebody off. All right, if not, we'll go ahead and conclude for the day. Thank you again for everybody that participated and to all of our panelists. And as Michael said earlier, for everybody's patience and everything with happening to do this in a completely different format than we were expecting to do so. For those of you that are registered, watch for that email coming from the State Bar. It'll be sent by Mike Mellis as far as the links for reporting your credit. If you were not registered, you can self-report the credit, but if you were registered, just wait on that email. And all of the materials for the presentations were sent out to everybody that was registered, but those will be posted on the State Bar's website. And again, we did record this and we will get that posted for additional free CLE credits under a special tab on the State Bar website. We've been trying to make as many of our past State Bar presentations available since we do have that waiver on the online credit limitation. So if that's no other comments from anybody else, appreciate everybody being here. Thank you.
Thank you very much, everybody.